guy's a pro. He's got an invader hat on. Nice. He was like, nice.
I don't think he remembers me.
Aw, that's nice.
Yeah, I'm trying to remember the name of that character from Invader Zim.
Microphone and this hat.
There we go.
Lots of innuendo flying around this.
That's right.
Good to go? Excellent. Hello, ETH Denver 2023. Gather around. This is one you're not going to want to miss. Welcome to Regulate Me Daddy. We're going to be talking about all things legal happening in crypto. But of course, we needed to assimilate to ETH Denver a little bit to bring you in. My name is Jeff Revere. I'm the head of tokenization at Republic Crypto. We have an amazing lineup, and I'm going to do some quick introducrons. We'll start down at the end with Stephen Pally. Stephen is a litigation partner and co-chair of Brown Rudnick Digital Commerce Group. Next in line, we have Mark Goldich, who's the general counsel of Proximity Labs. Nextly, we have Sarah Helena Brennan. Sarah is general counsel of Delphi Ventures and Delphi Research. And then lastly, we have Gabe Lexnode Shapiro, general counsel of Delphi Labs. Can we give him a round of applause, please? Woo! Awesome. Thank you all for joining us here in my hometown of Denver. Let's go, we'll start kind of going down the line on this. We'll go back to you, Stephen, to start. But what were the types of projects that kind of drew you in to crypto? And just briefly, and then what are you working on right now and what's your area of focus?
I don't think it's on.
Maybe share.
How about this one? Here we go.
Yes.
Yeah, so the thing that got me interested in crypto back in 2015 was the idea that you could automate contracts. Particularly, I came from a background of someone who sued insurance companies for a living. The idea that you could automate the claims process using parametric smart contracts really was interesting. I didn't know that you could trade this stuff. It took me like a year before I realized that there were markets. I've never really been interested. I'm not a trader. And I'm actually a counter-trading indicator. And so the things that I'm working on now that are most interesting, I am a primarily disputes lawyer. I focus on regulatory advice, government investigations, and also disputes. I'm working on one of the large bankruptcies representing the Unofficial Creditors Committee. One of the coolest things I'm working on, though, too, is I have a client that is creating DeFi-specific insurance policies. They are a Lloyd's underwriter. They're a Lloyd's cover holder. They're actually writing real insurance. And no offense to something like Nexus Mutual, that's not insurance. This is actually a real insurance policy that would cover things like rug pulls or complicated exploits. So I would say those are the two coolest things that I'm working on related to crypto.
Thanks, Steve.
Yeah, so I started in crypto in around 2016, first with Bitcoin. What really drew me into it was just the idea of self-sovereignty and disintermediation and self-custody. I spent a long time defending banks for about a little bit over a decade, and I really grew to hate them and really, wanted to find a way to disrupt traditional finance. And after Bitcoin, I got really into Ethereum. And soon after that, I was a founder and founded a litigation finance platform on Ethereum. And these were all ways that I saw to sort of disrupt TradFi, disrupt big banks, give more power to individuals over their finances. I've stayed with that throughout my career since 2015, 2016, and most recently with proximity, some of the things I'm most excited about are furthering decentralization in the space. One thing that we're rolling out actually this week is something called Boss, which is a platform for decentralizing front ends, which in my opinion that's really the grail right now, as far as taking decentralization to the next step, the next layer, and finding a way for individuals to run applications locally and to access these these forms of finance without intermediaries from soup to nuts. And so I think the more we see growth in the space with regard to decentralization, and in particular those on-ramps and off-ramps and front ends, the better. So I'm really pumped about that.
Awesome.
So I'd say my answer is pretty similar to Mark's on why I got into the space. I have more of a public interest background and concepts around self-sovereignty, and not to get too dramatic, but like privacy as a human right, that sort of stuff really matters to me. What I'm excited about now is at Delphi Research, they are finally letting the lawyers have a column. So we, Mark, Gabe, and I have an article, a policy-leaning article, coming out today or tomorrow. So please check that and give us your feedback. And then at Delphi Ventures, we're always looking at like cutting-edge projects, and there's always something challenging and new to encounter, so it's pretty dynamic and fun.
Yeah, I love it.
So I got into this space mainly because I like creating weird legal structures and deals that are very complicated. I used to be an M&A attorney, and I did like very complicated like earn-out structures. But when I discovered crypto, I realized that would be even more weird and complicated. So I decided to focus my legal career on that instead. And yeah, it hasn't disappointed so far. Because like you can like reference the code of smart contracts in your agreement, and like say, oh, for this certain type of issue, like we'll defer to like the outcome of the smart contract and things like that. It just gets very interesting. Like a lot of the agreements I draft have like have like Solidity code as exhibits and things like that. And in terms of the coolest thing I'm working on, I would say it's probably working on a new type of foundation entity oriented toward DAOs. So like basically DAO adjacent foundation entities that are more trust minimized, like rather than just having like directors who just kind of have a vague duty to like the good of the community or something like that. Instead, you set up smart contracts and like cross-reference those in the constitutional documents of the foundation or whatever type of entity you're using. So they have very constrained discretion, and like they could even have like a time delay on some of their decisions, and then like the DAO itself could like overrule their decisions if they don't like that. So I call those cybernetically enhanced organizations, aka cyborgs, aka Borgs, and yeah, I'm pretty pumped about that.
Very exciting. We must all assimilate to the Borg eventually here for all of our Trekkies. And I guess I should have started with this, but am I supposed to say none of this is legal advice?
Oh, yeah.
Okay.
It's legal advice. It's definitely legal advice.
No, for me.
Oh, it's financial advice and legal advice and all
all
that
this
stuff, yeah.
Yeah. I have a disclaimer
The bill's
in my
in the
bag,
mail.
typically. Right. Well, so all kind of came into the space from really different interest points and found yourselves in some of the same arenas, some not, some commercial, some kind of community. But you're all involved with LexPunks, and you've been doing some really interesting work with LexPunks recently, and I think as it's related to crypto litigation and there's so much going on in the courtroom for crypto right now, it's kind of hard to keep track of, to be honest. So we just wanted to talk about really one topic, and I think it's pretty expansive. Steven, I'm looking at you again, or Mark. I may ask you to do a better job of describing amicus briefs and why those have been so important in crypto litigation as of late. From my understanding, it's like lobbying, but no one's been, court appointed to come and lobby. It's actually people who are not necessarily lawyers who can come and participate in these hearings and really help them move along.
Yeah, so typically in litigation, the only people who get to speak, can people hear me? Is this microphone working? Kind of, sort of. Maybe I should use use my trial lawyer
Use your
voice.
outdoor voice.
So I'll project. So usually in litigation, the only people who get to talk, who get to speak to the court, are the parties. We have a process in the United States where you can file a motion and you can ask the court for permission to be a friend of the court, which is what amicus means, a friend. So we first saw that, I would say, significantly in crypto in the Ripple litigation, where John Deaton filed a motion to be to represent some people as an amicus, and that case has attracted a lot of interest. It's actually unusual in litigation on the trial court level to see such a significant amount of amicus activity. I historically thought of it as only being something you'd see in appellate courts. But I think part of the benefit, and so we also did this, Alex Golubitsky is sitting back there, Alex and I, along with Gabe and LexPunk, we filed an amicus brief in the UkiDAO case in the Northern District of California. And that case involves a lawsuit against a putative DAO by the CFTC, our country's commodities regulator. And the court allowed us to be amicus and allowed 3 other amicus to submit briefing. I think what was significant there was that there was nobody to speak for the, I have to say putative, I don't know why, because I'm a lawyer, for the purported members of the DAO, and as amici, we were able to do that. So I would say that's sort of the import of amicus in crypto, being able to speak for and educate the court as to matters that they wouldn't hear otherwise in the absence of a defendant actually appearing.
Yeah, and,
Right, there's an interesting nuance there, right, which is worth pointing out. So regulators are starting to sue DAOs, right? That's the headline. People always thought that there was some risk of that because it is a DAO and it's not an existing well-known type of entity. It may be some type of weird partnership or some other type of entity where every single person who's involved with that can be sued and potentially be liable, right? So the point of what us going in there was to say, hey, DAOs are unique entities, right? Don't just assume they're a partnership. And actually they're sort of like technological tools more so than entities. So, we tried to, but there's a catch-22, right? Because if someone from the DAO goes in to try to defend the DAO and say, hey, I'm a member of the DAO and you're wrong, well, they just exposed themselves to liability. They now showed up, said, I am a member of this DAO, and now they might be the one who gets tagged for all the liability. It's called joint and several liability. So they almost can't defend themselves. So we, as friends of the court, were kind of the only ones who could step in without someone kind of exposing themselves. So that's kind of like the tactical nuance to this way of approaching things.
So does that, just a clarification for even me, can I participate in amicus brief?
You have to apply to the court to say, here's why we're relevant, why we care about this case, and then the court may give you permission to file.
And the nuance there too is, when you're an amicus, you're only an amicus as to the issues that the court allows you to be an amicus for. So it's not the same thing as being a party, being a defendant in a case. So as an amicus, you cannot respond to every single motion that, in the case of UkiDAO, that the government files. You have to get court-specific information. So it's definitely not, from a big picture tactical standpoint, it doesn't solve the problem of who speaks for the DAO when the DAO, and I'm using scare quotes intentionally, but when the DAO is sued. I would say, too, sort of from a risk standpoint, both from a technology, regulatory, and frankly, a personal risk, one question I would always ask when thinking about participating in a DAO is, what does that mean? What personal exposure do you have? It might not be pleasant to think about, but it is a cold, hard reality that our regulators in the United States certainly are not above going after individual members of these things. That's kind of the position that the CFTC has taken in the UkiDAO case.
Mark, were you going to add something? Or?
Yeah, well, in this case, the court obviously approved LexPunk's petition to be an amicus. This is a quintessential type of scenario where LexPunk will do this kind of thing for communities. Now, it's our mission to really support devs, builder communities, DAO communities. And so we're going to pick our spots. This was a really good spot for the reasons that Stephen and Gabe just mentioned, for us to file this type of petition. But as the regulators get more active in the space, as they attack more DAOs, and as we see new novel issues, so matters of first impression, and in particular ones where members of the DAO may not speak up for themselves, may not enter an appearance, and there may be a default judgment, which could create a body of law that's harmful for the community, that's where LexPunk will and others have done this too, will step in. I think it's really important that you have these kinds of advocacy groups, and that's just one tool in the toolbox that we've used. We're also working really hard on policy, as Sarah mentioned earlier, working on just policy papers, working with different policy makers and trying to really shine a light on the issues that matter to these builder communities and to DAOs in general.
Awesome. Anything you want to add?
Yeah, I think that just in general, it's part of a trend. I think this year we're going to see a lot of advocacy through different means of litigation and possibly preemptive or proactive litigation. That's just kind of where we are from a regulatory standpoint. So I think it was a trend that kind of established itself, but will continue.
And I would say too, from a trend standpoint, what you'll see in this preventive or proactive litigation, you're going to see challenges based on the Administrative Procedure Act. You'll also see the use of what we call in the United States extraordinary writs of mandamus and prohibition. There are ways to compel regulators to do things that they are supposed to do or to not do things that they're not supposed to do. Those are not easy remedies, but those are three paths that I see for people who want to take on regulatory actions. Yes? What's that?
The three things.
Yes. So I would say the three of the approaches we will see people use to act preemptively or prophylactically against regulators will be the use of the Administrative Procedure Act, Declaratory Judgment Act as well, and also extraordinary writs of mandamus and writs of prohibition. Would take a little bit too much time here to explain all of those in detail, but high level, those are the tools that as a litigator I see folks using. Prohibition, mandamus, APA.
Get all that? We'll have show notes. I think we're probably going to stay on the tune of DAOs. I'm just going to kind of eke it into that even more. I think that's what most of this audience is. I myself, I've been participating in DAOs for a very long time. I've watched dissolution process, and it's confusing. I think it's confusing too because you have token holders, and these token holders are members. They're not necessarily participants, right? So you have this spectrum of participation in an ownership kind of model, and it's very, very nascent. So it's going to be a long road, but we've got some really good models in place. And so I guess what I want to talk about next is both project founders and token holders for the last, since Ethereum mainnet, have been in this kind of looming doom space with I'm going to issue a token, what's going to happen? I'm going to receive and take receipt of a token, what's going to happen? And that's really been securities law, right? We've had securities law kind of jammed down our throats for the last, call it 7 years. What are some other things that we should be on the lookout for as it relates to commodities, protections for consumers? What are some other things that we should be looking at as DAO members?
I could definitely hit that because I do a lot of DeFi stuff. And I would say, again, it relates to the Oogie DAO case, but a little bit of a different issue, which is there something illegal about a DeFi protocol? Do certain types of DeFi protocol violate certain financial regulations? And the allegation in that case, which actually was also against the original developers, not just the DAO, was that there is a commodities law in the United States that says it is illegal to conduct or to offer a leveraged, margined, or financed commodities transaction involving or among retail persons, unless it's on a very specific type of exchange that is approved and closely regulated by the CFTC. And obviously, as you might imagine, that exchange requires all kinds of KYC and controls. It would be impossible for any DeFi protocol to comply with that, even if they wanted to. Even if you went into the CFTC and said, "Hey, I want to register my Aave fork as a designated contract market," they'd be like, "What? Huh? You can't, dude. It just doesn't work like that." So basically, they said, well, if you created this protocol and you did things like adjust the parameters of it, like a credit protocol, like an Aave or something, such that people can generate leverage off their tokens, you are violating this provision because your smart contract system is not one of these approved exchanges, right? So I think that's the first case like that they have brought. That is, as I would say, that's even a bigger issue than the securities law issue, because
Commodities.
the securities law issue, you can kind of, like, there is such a thing as legal unregistered peer-to-peer securities transactions. You could do that, right? There are different ways, but with the commodities thing, it is designed around a philosophy of mandatory intermediation. So there is no workaround to that. So unless the laws are revised to accommodate that in some way, or the CFTC just decides only to go after, bad actors, so to speak, and leave the other ones along, that's like a head-on full paradigm clash that's even worse than the securities laws. So like right now, for example, I'll just say I'm a contributor to Mars Protocol, which is like a Cosmos ecosystem credit protocol, that involves leverage. And from the front end that, our company runs related to that protocol, like we geo-block the US. And we don't only geo-block the US, we geo-block VPNs as well. So, we block VPNs so that people can't end run it. So I think people have to be doing that for now, unfortunately, if you have that type of protocol. And luckily, the rest of the world is currently kind of more tolerant toward it, and we'll kind of see where it goes in the US. But yeah.
So yeah, I think that's like a really big note to hit on. It's like, hey, we're really afraid of securities coming onto our exchange, or me handling a securities but there's actually an even stricter law when you're handling commodities. And that becomes really interesting when you're dealing with AMMs. Because I can come in and I can create my own pool, right? These things are made to be open networks where you can create LPs and you can create positions. So let's maybe talk about personal liabilities in this case. I'm coming onto an exchange, they've given me the tools to do so, but perhaps I'm bringing a commodity. Who's at fault there? Is that the exchange providing the technology for that to be open and for people to do that? Or is that to the individual who's personally liable for bringing a commodity into that space?
I would say you have to look, I can tell you that regulators are looking at everyone who's involved. People who operate front-end websites, they're not necessarily buying the argument, well, we're just a website that hooks into a decentralized protocol. Now, they may be wrong, but I'm not finding a lot of traction with that argument. There are also questions about people who are setting up AMMs, using somebody else's website, using someone else's technology. I would also say that an area of law that I've long thought would be applicable in crypto, we're just starting to see, I think we're starting to see a wave, is UDP type claims, unfair and deceptive practices claims, both from state regulators and federal regulators. I think I saw last week a new enforcement action from FTC. You're also going to see the CFPB going after folks. I mean, the question is, there's almost two paths. One path is totally degen anon, incredibly careful OPSEC, nobody knows who you are. The other is tightly regulated or avoid the United States. If you operate in that gray area, you're looking for trouble. Basically, the gray area that we had for maybe 5 or 10 years, which maybe wasn't so gray, is happy hunting grounds for U.S. regulators.
You don't have a predictable outcome, basically.
Yeah, that's right.
And when Stephen mentioned UDP and CFPB, he's talking about consumer protection statutes, and consumer protection laws, and those are very, it is very applicable, and you can see an area where better disclosures it would really be helpful. It could really be a way to reduce liability if you do run a website, you do run a protocol, you do have a new product, to have just best practices that really do speak towards the issues that consumer protection statutes try to solve for. And it would be a really good regime. Unfortunately, in the U.S., the CFPB for many years was toothless and didn't actually help consumers. And now that it's ramping up maybe a little bit, it's being run. It's Senator Warren's baby, and we know how Senator Warren, what she thinks about crypto. So the CFPB isn't going to be a great spot for crypto in general going forward.
Yeah. So just looking at time, and maybe this is a good place to round up. I mean, I kind of want to ask you guys like favorite color questions and stuff like that, but I'm not going to. So with that said, and I mean, we're going to be innovating way faster than regulators, right? Like I think that's a constant that we should be expecting. But like, what is the future for not just crypto, because we've had some assignments of crypto in the States, but what is the future for like advanced crypto in the US? What does that look like, and how do we get there? Like, we feel very helpless in the non-legal crowd. Like, what are we doing to get there, and what does that look like for the US?
Short answer is that I think it has to be based on a platform of software freedoms. Just like in the 90s, where the original like kind of crypto wars happened, it's kind of the same thing here, and that ultimately was won out on software freedom. So I think I think the important thing about software freedom is like it actually applies everywhere you use software. Like I've seen certain regulatory policy positions of like, okay, regulate the websites, but leave the base layer alone. I personally don't think that's very doctrinally coherent, and I think if people were to create a regulatory regime around DeFi websites or whatever, people would end run it, the regulators would see it's being end run, and then they would ultimately go after the base layer anyway. So I think you have to draw like a hard line, software freedom, just using software or publishing software or making it available or running it for yourself on your own account is not as an intermediary. There has to be a hard line there, and we have to like almost have like an NRA type of approach, that this is a fundamental right, basically. And I ultimately think that will win out, just like it did in the crypto wars, as long as people are very consistent about it and that it's about software freedom. Because at the end of the day, I think almost anyone can understand that intuitively, why it's important.
I love it. Yeah, let's go right down the line.
I also think that the U.S. is just not going to be a leader. Europe is at this point. And so we always talk about like the war on drugs analogy. It's getting legalized and brought into policy frameworks around the world. So the U.S. can't like maintain this stance coherently indefinitely.
And I wonder if that's a strategy. It's like I don't want to be first to market. I want to be best to market. It's like stumble out in front of us, and then we'll step in and basically do something that's tax beneficial to the states. Who knows, but could be a strategy. Doesn't seem like one right now. What do you think?
We do a lot of psychoanalyzing of regulators.
Yeah, I can imagine a lot of circles.
Looks like we're about to get the hook. I saw.
Well, they're gonna wait for Mark and you, man. Let's go. Mark, what do you think, man? What
well, I just parrot what Sarah said. I mean, the U.S. is not going to be hospitable, and they're going to have to find out the hard way that they're lagging behind the rest of the world, and then ultimately change their tune. I think that will happen, but they're not going to be a leader.
Does anyone have any quick questions? I think you might have had a question. Yeah, go ahead.
Thank you. Absolutely great information. I'm a lawyer myself. What I'm noticing is that we talk about all the money that's made in this space, but we do not lobby. We do not lobby, right? So I'm thankful that we have lawyers like yourself who are in this space, but the thing is exactly what you were saying about having an NRA approach, about we see companies like Circle, Coinbase, right, who are lobbying. However, we as a community are not lobbying. So when we go and start talking about the regulators don't understand, the legislators don't understand, don't talk about all the money that you're making and you're not being sophisticated enough about going and lobbying. So that's my point.
Yes.
You know, I'm known as the crypto politician. So yeah.
Right. It's like why don't we coalesce around a DAO that does fundraising for DAO? And I've been barking up that tree for a long time, and it seems like no one wants to step out on that ledge. But you know, these folks are, and they're doing that with Lex Punks, and they're doing that with amicus briefs, and they're doing that to kind of step in and lend their time. And I think that's the first step. Steve, do you want to give us maybe a close?
I am extremely bullish, actually, and I think the United States will continue to be a place where people innovate. The law takes time. Eventually, things will catch up. We're not there yet. I think what we're going to ultimately have to do is have a more robust regulatory regime that covers software in general, more broadly written, and we will eventually stop using securities laws that were written in the 1930s to apply to 21st and 22nd century risks. But long term, I'm bullish as hell.
Let's go. Let's be bullish and positive, right? I think that's gonna forge about that. All right. Thanks everyone. Thanks ETH Denver 2023. Thank you to our panelists.